we talk about as attorney security negligence cases, we're usually talking about apartment house type situations where the locks are broken in the front doors, the landlord doesn't do anything about it, the light bulbs are out, the landlord doesn't do anything about it, and then something horrible happens, like an assault or a rape. They are difficult cases to prove. There's a different standard in New York State about those cases, and there's different jury instructions regarding those cases. For example, if the assaultor, I should say, the person who commits the rape or the attack, is actually found and charged, then the landlord will get a charge that apportions the liability between the person who did the assault and the landlord. And what that effectively does is take the liability off the landlord and put it on the person who actually committed the rape, and therefore takes the dollar value out of the case. If they don't catch the perpetrator, then the security and the liability is pointed at the landlord. And then you must prove that the landlord had notice of this condition or should have had notice of this condition. And when you say notice of the condition, meaning that people complained about it and he never did anything about it. Those cases are analyzed on a case-by-case basis because they're a little bit more complex, and the case law seems to be, unfortunately, more in favor of the landlord than the person who was the victim in the case.